but we will, it looks like we're live. Good afternoon. This is a meeting of the House Criminal Law Subcommittee. It is February 28th. We are continuing discussion on two bills. I hope we can take a quick straw poll on where folks are at on those. There are some amendments to discuss too. And then we have a third new bill from Delegate Shetty that I hope we can at least talk about very briefly, just to get our feet wet on that one. But before we do that, why don't we skip to back to House Bill 128. Very briefly, this was Delegate Rosenberg's bill about creating a crime to mirror the judicial crime against interfering or threatening witnesses in a judicial proceeding. And the proposal was to bring that over to legislative process threats. And Chris, would you mind putting the text of HB 128 up on the screen so that we can quickly do this while looking at the actual bill? Can we? All right, so here we go. So there's a task force. Here's the new prohibition that is sought to be codified. Everyone can digest this one more time. A person may not harm another, threaten to harm another, or damage or destroy property with the intent to influence a witness to offer false testimony or withhold, or to make them absent. So, and Chris, would you mind scrolling down so we could see the penalty that's proposed for this infraction? Misdemeanor, 10 years. Sorry. All right, Chris, if you don't mind scrolling back up to the section of code where it defines the crime. Here we go. So the sponsor has offered an amendment conceptually. If you look at line 17 of what's on the screen right now, a person may not harm another, threaten to harm another, or damage or destroy property. And his amendment proposes to remove the property element here. So that is the proposal as it currently stands. Is there any discussion before we straw poll this, Delegate Cardin?
I just want to ask maybe the sponsor a quick question. So if I have a basic contract concept, I own a business, I'm hiring somebody, and I say to that person, as part of this, first of all, if you take off of work to go testify, I'm going to dock your pay. And part of the agreement is that we don't testify. Let's just say, for the sake of argument, we don't testify in Annapolis as part of your employment here. So it's a basic contract. You can sign it. You cannot sign it for your employment. Are you then violating this law? I mean, there's a whistleblower issue, which I think that transcends this. So if you're whistleblowing something about the company, that's a whole different story. But if part of your contract, I mean, you're either violating you're going up against contract law, or you're violating the statute. It seems like. I'm just curious about that.
Well, let's just gather commentary at the moment because I'm trying to do this quickly. Delegate Grammer.
Thank you, Mr. Chair. That problem worries me less because you can't give up a right. The question I have is, how is harm defined? We've had several bills this year where the word harm is put into place, and I don't see it as defined anywhere in this bill. So I just want to figure out what the definition is.
Delegate Embry.
Thank you. And I know I've said this before, but in my view, the possibilities are, there's the lack of the definition of harm, as Delegate Grammer said, just leaves open the possibility of criminalizing behavior. Another thing I thought of recently is someone is on the board of an organization and then they testify in some way that is completely offensive to the mission of the board or to the members of the organization, and they want to then remove the person from the board. Would that be harm? I think it's too broad a brush unless we are more clear about the harm.
Okay. So very quickly then, I would offer there are a few paths here. Four paths perhaps. One, we could do something like limit this to a physical harm or injury. Two, we could actually sit down and define harm, and that would certainly mean we're discussing this a bit more. Three, someone else has a different idea. You're certainly welcome to amend the concept further. Or four, an unfavorable. So, can we just quickly? Does anyone have theories of the case about direction that would lead to an amendment?
Yeah, Mr. Chair, I'll leave the specifics up to you, and maybe we should just limit it to physical harm, but I would be very much opposed to an unfavorable because I think that this is a very worthwhile, Delegate Embry makes some very good points about how the devil's in the details, and I would leave it to the lawyers on the committee to iron it out, but I would be opposed to letting it die or voting unfavorable for it.
All right, Delegate Sample Hughes, and then we'll circle back to Grammer.
Sure. Thank you, Mr. Chair, for the options that we had before us. I guess if we just left it to the physical harm, it doesn't speak to why Delegate Rosenberg brought the bill forward in the first place. He's kind of going more towards the financial impact that's harming the pharmaceutical industry as far as the pharmacists locally. So I think it begs us to define harm to get a little bit to the meat of the problem, and whether that is physical, but also possibly the financial impact that's been the concern as well.
All right, Delegate Grammer, very quickly.
Yeah, absolutely. So my sense is that if we sit here and try and define harm and really try and narrow this down the way it should be, the lack of time for this subcommittee is probably going to kill the bill. And if it were me, I would probably want to go back to the two bill sponsors, convey our concerns to them, and maybe give them an opportunity to work this out. And I think that's probably the most expedient way to address everybody's concerns.
Delegate Rosenberg is here with us at the moment. We don't have the benefit of Delegate Kipke. Do you have any theories of the case, Delegate?
Well, I think there are two options, and I would take the burden on, if that's okay with the committee. One is the dictionary definition, which is the conservative way of going about this. And the other would be to see if, in interpreting the statute for the judiciary that this is modeled upon, has the Court of Appeals or the Court of Special Appeals defined harm. And so I would seek counsel there from the AG's office. So, and I will get back to you before your I assume by next week.
Okay. All right. Thank you, Delegate. So I guess we'll put this one on hold for a week pending additional information. Thank you.
Sure.
All right. Let's flip now back over to Delegate Attar's bill. This was House Bill 321. This is about arson and adding a 10-year felony if it led to the injury of a firefighter, with an additional amendment proposed to have if it led to the death, I believe that one's a 20-year felony. And Chris, once again, can we pop the relevant portion of text up on the screen while we discuss this one?
Yep, 1 second.
All right, so hands up. While this one is going around, Delegate Cardin, you want to just get us started?
Yeah, I'm trying to say this as expeditious as I can. I understand the intent of the bill. I like the idea of a potential enhancement, but I think that there needs to be some guardrails on this. I'll just mention 2 points that I wrote down. First of all is, what if there is some degree of negligence on the part of the firefighter that could have been contributory or in some way is learned during a civil case after the fact, but the person might already be in jail for 20 years because the criminal case happened before the civil case began. And then the other question that we brought up last week is, what if the firefighter dies on the way by a car accident, maybe by the fault of another person, maybe by his own potential negligence, on the way to putting out a fire that there was never any intent that fire was meant to hurt anybody. I just think, I understand we want to have an enhancement of some sort if there is a death or a serious injury of a firefighter, but it should be limited to when they're actually trying to put out or deal with or control a fire, and not maybe ancillarily when it's an issue of an injury because of an ancillary action. And I just think that we need to really think about this, because I could see a vigilante prosecutor, a vigilante judge using this in a way that was never intended to be. And so I just want to make sure our intent is right on this. So that's my thinking.
Delegate Arikan.
Thank you, Mr. Chair. Yeah, I just want to echo a little bit of what Delegate Cardin said. This is a good bill. We just need to tighten it up a little bit, I think. I also had some concerns during the hearing about, what's the difference between somebody lighting a house on fire, residential, and somebody lighting, trash on fire. I think we want to get at those people who are clearly a menace to society, who have, with literally no care for life and limb of others, have committed a arson that could be reasonably expected to result in the harm to another, versus somebody who's foolish and is doing something silly, like lighting their trash on fire in a trash can. And totally agree on the topic of ancillary injury. There's definitely a way for us to say that it has to be the direct result of the action of arson versus, obviously a car accident or something like that on the way there. But I think we can tighten it up, and maybe council can jump in and tell us how we would do that. But I think those can be addressed, and we can move this bill.
Delegate Grammer.
Yeah, I was just going to nominate Delegate Cardin to come up with a solution and give us an amendment.
Well, let me throw my question out here, and it's sort of one on fundamentals. And that's, I was trying to think back to the case examples that were presented for this, and so I'm glad we have some of those folks on here. But the thing I'm having trouble wrapping my brain around is I'm looking at the existing penalties for arson, which go 20 to 30 years, essentially, if someone's life is in danger. And I suspect the penalty is that high, near murder and attempted murder penalty levels, because of the inherent risk of injuring a human when you set fire to a building or structure, at least as to first or second degree arson. And so I'm curious, back to the use cases for why this bill was needed. What happened? There was a failure of the other available charges, and this really is a true gap in law, versus did something just go off in a case here or there? And Delegate Embry, I see your hand is up.
Oh, do you want that to be addressed first, or should I?
No, go ahead. We're just piling it up.
Okay, so this is I think a really interesting concept, but I share the concerns already expressed, but also 57104 of natural resources, it carries a 30-day jail penalty. And so we're tacking on 10 years for an injury. And, you know, injuries vary obviously in severity. So I just, again, in the guardrail, looking at carefully what we're doing, just being thoughtful about what kind of injuries are we talking about, what kind of actions by the person who's being charged in the burning. So I just wanted to raise that issue.
Sure. Delegate Roberson.
Yeah, and I guess since we're sharing our views around the bill overall, it's less of, I'm just concerned about the extension for the additional 10 years regarding the bill, and just looking at current law, how if a person sets fire, they already can get up to 20 years or 30 years, depending on first degree or second degree. And so my I just, an additional 10 years, I feel as though it's piling on. And I feel like under current statute, they already have the ability to do that. And so maybe I regret saying this, but I just think that where we are now works, in my opinion. And so, I always ask myself the question, what is this trying to solve? And I don't see how this legislation is solving a problem based on current statute.
Great. Okay, so we have some of the stakeholders here with us from, I believe, Baltimore County and the firefighters. And we don't have too much time because we're in committee at 1:30, and I'm trying to squeeze in a quick talk on another bill. But if you have any comments or clarity you want to address, having just heard that round of commentary and questions from subcommittee members on the bill, we would certainly welcome any additional conversation. Lauren Lipscomb, go ahead.
Thank you so much. I did want to just reiterate that this bill is designed to capture what we as prosecutors are having trouble with in terms of charging and being able to hold those individuals accountable for the death or serious injury to firefighters when they've responded to the scene of a malicious burning or some burning of a structure that is less than an arson. And so, yes, we do have the felony murder statute there that we can use for felony murder. And of course, we also have a second degree felony murder statute. But the issue, this is in direct response to issues that prosecutors are having, holding individuals accountable for the life-threatening injuries or death of firefighters in direct response to fires that have been set where the requisite intent, which is specific intent, which is what we have right now, is not necessarily met. And the appellate courts have interpreted the statutes that we have now as being specific intent, and that specific intent needs to follow to the death or the serious injury of a firefighter. That's just kind of number one. Then I just wanted to throw out a suggestion before turning this over to one of my colleagues, ASA Colin Campbell. In terms of the capturing those cases in which a firefighter would be responding to the scene of a fire, I think that we would be able to perhaps add some language that narrowly tailors this enhancement bill to those firefighters who are injured or killed while on scene fighting a fire. And so I certainly could work with Delegate Attar to draft up some language that would address that specific.
And sorry, could I just ask another question? Couldn't this be done by writing a penalty enhancement into the malicious burning section of the code specifically? And just
I think it could be. I think it could be. I'd have to take a closer look. I've got all of the codes here in front of me, but I'd have to take a closer look at it. Maybe ASA Colin Campbell might be able to answer a little bit more readily.
So that is sort of what the intent of this bill was to do. There's currently no penalty structure in place for what would essentially amount to an assault level of injury for a firefighter. And that's sort of the issue we're having. We're having issue presenting reckless endangerment and assault of firefighters on the scene who are injured as they responded to the scene. They weren't there at the onset of the fire. And so the specific intent normally needed for their injury, it doesn't transfer to them. And so that's where we're having an issue.
Got it. So to Delegate Embry's point, felony murder might cover the death scenario, rendering that Second Amendment potentially moot. And if we just sort of focus on the core issue here, it sounds like, again, we're talking about malicious and a penalty enhancement specifically for malicious burning. Delegate Cardin.
You know, you said exactly that. So we're really looking, I think, your intent, Mr. Campbell, is to deal with the malicious burning, not necessarily the arson 1 and arson 2, which already carry, 20 years or 30 years accordingly, right?
So they do. The issue that I ran into most recently was the inability of the firefighter who was injured on scene to actually have a count.
Right.
In relation
I understand that. So they couldn't. But the argument to the judge at sentencing could be the person should get the full 30 years, especially since a firefighter was injured or killed at the scene after the fact.
And apologies, I'm gonna cut our convo on this one short right here. Get a very quick one sentence from OPD. Counter here. You got 30 seconds here to pipe in.
Just generally, we would encourage the consideration if this is meant to address like an assault level injury, or as Madam Lipscomb said, State's Attorney Lipscomb said, a serious injury, maybe mimicking the definition of first degree assault, which does say, serious physical injury to another, or serious or deadly injury, something like that. That's just what we wanted to add, because the injury definition, there is no definition right now. Thank you.
Great. So can we put that homework to try and steer language back on the sponsor and proponents of this one? All right, we'll circle back to that one next week also. All right, we have 3 minutes to pull up Delegate Shetty's bill. This was House Bill 496. And this was around the definition of consent and whether there is or isn't a force requirement, and whether that needs to be clarified in the law. It is up on the screen. Do we have Delegate Shetty here? Yes, we do. Delegate Shetty, we just have a few minutes here before we have to jump to committee. Do you want to just quickly refresh us in a sentence what this bill purports to do and what the amendments you are proposing would do differently than what we heard at the hearing?
Sure. Thank you, Mr. Chair. Thank you, colleagues, for allowing me to speak. This bill would provide a definition for consent for the purposes of engaging in sexual activity and removes the force requirement as well. The amendments, one of them I think is technical. The second one was proposed by Senate council as like a kind of a fix to a small issue. Is Lisa Jordan's on here as well, and I'd love to just have her describe that one if possible.
Yeah, if you could very briefly describe that amendment, and then after that, I'd like to get one of the opponents on to give at least a sentence for us to think about while we kick this bill. But go ahead, Lisa Jordan.
Thank you, Mr. Chair. Thank you, members of the committee. The amendment is completely stylistic. It simply switches, for purposes of determining whether lack of consent exists, it switches basically to in this subtitle. So there's not a substantive change in the law. It conforms to kind of standard drafting in the Maryland DLS handbook. So certainly from my point of view, it doesn't make any substantive change, but is a little easier to understand. So we support this.
And sorry, just for the committee's education on this, is the bill attempting to solve a problem where people aren't criminalized at all who should be, or is what we're arguing about what the penalty should be for people who are being criminalized?
it's trying to fix a situation where people are not criminalized at all, particularly in freezing cases. So we have survivors who freeze up in the face of a sexual assault, and because we're unable to meet the force or threat of force requirement, there is no prosecution at all. And so we're leaving those survivors without any sort of justice. And then it also is now conflicting to the education article, where we have a different definition of consent for the mandatory consent education. So we'd like to have the criminal law and the education article conform to one another.
Great. Okay, we have one second left for a comment from one of the opponents. If anyone wants to weigh in with, yes, Christine Dufour, you have like 30 seconds to tell us why not.
On behalf of the MCDAA, I would oppose this elimination of the force. I'm not going to speak to the definition of consent. If you eliminate force, you really de-elevate this right down to what 4th degree sex offense is, which is also the only other sex crime that has simply the element of lack of consent. These perpetrators, if the freezing instances, can be charged with assault in the 2nd degree, which is 10 years, or 4th degree sex offense. With regard to 2nd degree rape, if you eliminate the use of force and you just go on the element of lack of consent, you have a felony, 20 years with lifetime registration. We believe force should remain an element. We have a scheme of 1st degree, 2nd degree, 3rd degree, 4th degree. And if you eliminate force, you really de-elevate again what it means to be 2nd degree rape. And rape is on crime of violence statutes in the public safety and the criminal law. There's a reason, because it's a violent crime. It involves force, however slight, and that's for the jury to determine. So we'd ask that this committee not adopt the elimination of the use of force. We'll leave it to the committee as to the definition of consent.
Thank you, colleagues. Delegate Eric Henham, I apologize. I think that's all we have time for today. We are going to be back with all 3 of these bills for a much fuller discussion. This time, folks, if you have amendments, please think through this in advance so that we can, obviously floor time is cutting into subcommittee time these days, so we got to be